Welcome to FedSoc Forums, a podcast of the Federalist Society's practice groups. I'm Nate Kazmarek, Vice President and Director of Practice Groups at the Federalist Society. For exclusive access to live recordings of FedSoc Forum programs, become a Federalist Society member today at fedsoc.org.
Hello, everyone, and welcome to this Federalist Society virtual event. My name is Marco J. Lloyd, and I'm the Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host the webinar Courthouse Steps Decision, E.M.D. Sales Inc. v. Carrera, featuring Michael O'Neill. Mike serves as Vice President for Legal Affairs for Landmark Legal Foundation. A graduate of Villanova University and the Catholic University's Columbus School of Law, he specializes in constitutional and regulatory legal matters. He has also authored numerous amicus briefs with the U.S. Supreme Court. His full bio can be viewed on our website, fedsoc.org. If you have a question at any point in today's program, please enter into the Q&A function at the bottom of your Zoom window. We will do our best to answer as many as we can. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speaker. With that, Mike, thank you for joining us today, and the floor is yours.
Thanks a lot, Marco. It's a pleasure to be with everyone this afternoon. Shortly, oral arguments in this case, E.M.D. Sales versus Carrera, took place just a couple of months ago, and we had only 2 months between the conclusion of oral arguments and the issuance of an opinion. So January 15th, just a little bit more than 2 months later, the court issued an opinion in this case. The court issued a very short 9-0 opinion, and the issue here presented was what was exactly the evidentiary standard that was going to be applicable when determining the applicability of overtime of the FLSA, the Fair Labor Standard Act's minimum wage and overtime provisions. In this case, E.M.D. Sales is a Maryland employer that employed approximately 150 employees, a fairly small wholesale food distributor operating in the Mid-Atlantic. The respondents in this case, employees of E.M.D. Sales, were 3 individuals who were based out of Maryland. They were designated by E.M.D. Sales as sales representatives who worked more than 40 hours a week and were paid on a commission basis. The issue at trial in Maryland, a Maryland district court, the issue at trial was whether these individuals fell within the Fair Labor Standard Act or the FLSA's overtime and minimum wage exemptions as applied to outside salespeople. Now, the question again here was what was going to be the applicable standard of proof in determining whether these individuals fell within this outside sales exemption. In the Fourth Circuit and in the Maryland District Court, and by extension, the Fourth Circuit applies a higher, clear, and convincing evidentiary standard. Other circuits, in contrast with the Fourth Circuit, apply a lower preponderance-of-the-evidence standard. A 9-day bench trial occurred whereby the court took extensive evidence on the actual applicability of these provisions and heard from a number of witnesses regarding the specific role of these individuals. Again, the court was applying a higher, clear, and convincing standard, as is the case in Fourth Circuit precedent. The district court had required the E.M.D. Sales, E.M.D., the corporation or the employer, to prove by a clear and convincing evidence that the outside sales exemption applied. Number one, whether the individuals made sales in their roles as sales representatives, and 2, whether their making sales was their primary duty. Again, the court applied a higher, clear, and convincing evidentiary standard in making these determinations. The court found that respondents, in this case again E.M.D. Sales, had made sales had indeed made sales. They had cleared that higher evidentiary burden. However, the employer failed to establish that that these individuals functioned as sales representatives in their primary capacity, and whether they actually completed outside sales. The court had concluded, again, the district court concluded that this higher evidentiary burden was not met. The court did say that there was essentially this is a district court ruling on concluding after a 9-day bench trial. The district court did conclude that there was a lot of really close evidence and close calls. But because, again, of the higher evidentiary burden, this outside sales exemption did not apply. The employer, E.M.D. Sales, again, appealed this decision to the Fourth Circuit, who of course, affirmed the district court's opinion, applying its default clear and convincing evidentiary standard. This, again, in turn, this case was then appealed to the U.S. Supreme Court for a determination. And as I said, in a 9-0 decision, in a tight, I think it was about 11-page decision authored by Justice Kavanaugh, the court concluded and ruled that the Fourth Circuit had erred and set forth a uniform standard. First, the court noted that when you're applying evidentiary standards here in the context of civil cases, the default evidentiary standard is preponderance of the evidence, and that there's only certain exceptions for the higher clear and convincing standard to apply, and that the Fourth Circuit's application really was an outlier. In other words, there are six circuits that apply a lower standard in FLSA exemption cases, and the Fourth Circuit was really the outlier and hadn't properly really ever established why it was utilizing this. Let's break it down a little bit here and why, and some of the analysis of the U.S. Supreme Court and its decision, why it decided this case, and what are some of the implications going forward. First of all, again, let's back up and say, what did the Supreme Court hold? Well, the Supreme Court held that when you're applying FLSA exemptions, the preponderance of the evidence standard is applicable in all in these cases. In other words, the Fourth Circuit's clear and convincing standard is no longer applicable. The court looked into when and where and how courts are going to utilize the higher evidentiary standard versus the lower evidentiary standard. And the court noted that there's only really three instances. Justice Kavanaugh noted that there were really only three instances whereby a court is going to deviate from the preponderance of the evidence standard. Justice Kavanaugh noted that the first instance is when a statute establishes a different standard. If the statutory language says something to the effect that specifies that you're going to use a higher evidentiary standard. So if you have statutory language specifying an evidentiary standard, obviously that's what's going to be applicable here. The second instance is when courts are supposed to deviate from, again, this standard, the preponderance of the evidence, the default evidentiary standard, is when the Constitution requires a higher evidentiary standard. Of course, these are cases involving the First Amendment, due process cases such as involuntary commitment cases, parental rights. If you're implicating constitutional rights, you're going to have again the higher evidentiary standard here. And then the third instance when courts are going to deviate from the preponderance of the evidence standard is in uncommon cases like citizenship revocation. And the court was noted that these are rare and rare are rare instances. So really we have three instances that are specified by the court in the context of a civil lawsuit. Obviously, in criminal cases, you're always going to have your highest burden, reasonable doubt. But in civil cases, you're going to have three instances where courts are to apply a clear and convincing standard as opposed to the default civil case, the default civil preponderance of the evidence standard. Again, when the statute establishes a different standard, when constitutional issues are at play, again, First Amendment, due process cases such as involuntary civil commitment or parental rights cases, and then uncommon cases like citizenship revocation. Those are really the three buckets where you're going to apply these higher evidentiary standards. And of course, none of these buckets are applicable to FLSA exemptions. And so therefore, the default preponderance of the evidence standard should apply. This is really, again, it encompasses the tight ruling of this 9-0 decision in E.M.D. Sales versus Carrera. So the court wasn't swayed. There was a lot of, and I was fortunate enough to participate in a panel discussion earlier, shortly after oral arguments. And I'd kind of gone out on a limb and surmised that the court was going to rule a 9-0 decision based on some of the questions I heard, based on the context of oral arguments, and basically how oral arguments really, for lack of a better term, went down. It was my guess, listening to the three justices that might have been most predisposed to rule in favor of the employees. Again, these individuals who were asserting that they did not fall within this exemption, that they were asserting that they were entitled to overtime, back pay, that the three Justices Kagan, Jackson, and Sotomayor, based on their questions, it appeared to me that they really had concluded that they were predisposed to rule in favor of essentially setting the Fourth Circuit straight and setting the Fourth Circuit in line with the other six circuits who utilize this evidentiary standard. And there was a brief summation, brief analysis of oral arguments and some of the arguments that were proffered by the respondents in their defense, trying to say why the Fourth Circuit's decision should be upheld. I think you saw a couple of arguments that were proffered. Number one, it was a decision essentially that they argued that from a policy perspective, that in order to ensure a clean balance of power, a fair balance of power between an employer and an employee, essentially an employer will have a higher will operate from a higher power than an employee. There won't be a fair balance in equities, and ensure to have a fair level playing field for both an employer and an employee in the context of the litigation, that it's necessary to place this higher burden on an employer. So it was a policy argument proffered by the respondents here, by the attorneys for the employees. The second argument that they proffered was the non-waivability. They pointed to the fact that rights conveyed via the FLSA were not subject to waiver, and that kind of indicated a congressional intent that these particular rights were particularly important and therefore should receive additional protections in the context of this standard of clear and convincing for employers. And unfortunately for the respondents, the court did not buy any of these arguments. None of the justices brought onto these arguments. What really was dispositive, I think, in this was, and if you read the opinion, again, I encourage anybody out there to read the opinion. It won't take you very long. We're talking 11 pages here. I think what was dispositive, and the court, Justice Kavanaugh continues to go back to it, is the way Title VII cases are litigated. And he refers repeatedly to the fact that in Title VII cases, you're going to utilize Title VII cases. Again, these are sex discrimination cases. You're going to use the preponderance of the evidence standard in litigating those cases. And if it's good enough for Title VII cases, then it certainly should be good enough for FLSA exemption cases. And that really, I think, really kind of was reading a little bit into the tea leaves, reading a little bit into the opinion. I think you saw that really kind of was dispositive, in that if Title VII is litigated using this standard, this evidentiary standard, then these FLSA exemption cases should be litigated into it. What's really interesting here, and I think there was a touch on this there was a question by Justice Kagan at oral arguments on this, and I think it's a really interesting question if you really want to get into the nitty-gritty of this case, is why is the Fourth Circuit an outlier here? Why would the Fourth Circuit have this apply this evidentiary standard one way when you have six other circuits applied a different way? And as I said, Justice Kagan asked a question in oral arguments, trying to surmise what was the origin of where this came from. And interestingly, just as a quick little aside, as a story, I had I told this story earlier at our courthouse steps at our oral arguments analysis. I'd actually had one of our research fellows here at Landmark Legal Foundation, as one of his first assignments as a research fellow, try to discern the origin of this, of where the Fourth Circuit came up with this. How did they get on this path to utilizing this evidentiary standard? And this poor guy, despite his best efforts, really couldn't come up with it. And if you read the opinion, there's a little bit of a delving into how this came up, and they kind of got into it a little bit. And it's kind of this roundabout way regarding a misinterpretation of a 10th Circuit decision back in the 1980s from a Fourth Circuit case, and then another subsequent Fourth Circuit case from about 5 years later, 1991, interpreting that case in a manner establishing kind of a clean a rule that the Fourth Circuit from heretofore is going to be utilizing this clear and convincing evidentiary standard in litigating FLSA wage and overtime exemption cases, or going forward forever. And it's kind of just gotten a hold of it. And the Fourth Circuit's really withstood any efforts to change it. There have been two, up until this case, before this case, there were two efforts appeal to the Fourth Circuit en banc, to have them review this and overturn this and bring them in line. And all of those efforts had failed. So the Fourth Circuit had really dug in its heels in this case. And so it was imperative that the Supreme Court come in and say, look, Fourth Circuit, we're going to bring you in line with the other 6 circuits, and we're going to quietly admonish you for this. And anyway, and so I think it's interesting, if you really want to look into it, that how sometimes these cases can be interpreted over years, and a misinterpretation decades ago can still, the effects can reverberate for decades and decades until you have a United States Supreme Court coming in and kind of putting their foot down. So I think that's an interesting point. I think it's also interesting in that you've had the Fourth Circuit applying this higher evidentiary burden on employers. Of course, it makes it more of a choice venue for practitioners who might want to bring cases in these cases. So if you're an attorney, or if you're an attorney wanting to litigate these sorts of cases on behalf of employees, you're clearly, up until this decision, you were at an advantage. You were an advantage in the Fourth Circuit as opposed to in the other circuits. And incidentally, one of the gentlemen who was going to be on the panel with me earlier, he apologizes for not being here. He had indicated that he's a practitioner in this field, and he had indicated that he wasn't even aware that the Fourth Circuit was this outlier up until this case. So I think it's important for that regard to kind of bring uniformity and uniform application of the law throughout the country, of the federal law. I think. Interestingly, there was some surprise that the justices, again, Justices Jackson, Sotomayor, and Kagan didn't weigh in on the viability of these policy-based arguments, and he had expressed some surprise at that. And I would answer, I think that question is, well, why didn't Kagan or Sotomayor or Jackson take this opportunity to kind of weigh in on whether some of these policy-based arguments might hold some sort of merit? In other words, placing the employee and employer on an even playing field. And I would posit to you that I think that you have a 9-0 decision here. And I think just from observing these cases and watching some of these Supreme Court cases, that there is a concerted effort to have uniformity. If you can have a 9-0 decision that's really tight, and this case is a really tight decision, it doesn't get into, for example, we'll get into in other ways and how it's tight, then in order to have that tight decision, there might be a little bit of horse trading behind the scenes, that there's not going to be some sort of discussion on policy, or there's not going to be weighing in on whether the court is deciding, actually making a determination as to the validity of the arguments about whether the actual individuals in question, these employees, actually satisfied the burden or not, whether you see there is a reversal and a remand, and we can get into the consequences in a few minutes and how this case might go forward. But I think answering the question of why none of the justices actually addressed the viability of some policy-based arguments, I think that there was more of a thrust to have a tight decision, just simply focusing on the proper evidentiary standard to utilize in litigating FLSA exemption cases. And if you stay within the contours of that, and you read the decision for that within that context, you're going to kind of understand why there wasn't a little bit of extraneous talk. There was a concurrence, a very, very brief concurrence by Justices Gorsuch and Justice Thomas, joined by Justice Gorsuch and joined by Justice Thomas, which I think I'm going to get into in a few minutes, about what that might have meant and what those justices were possibly signaling in their concurrence. There's another important case that I wanted to touch on that wasn't discussed in the opinion, but was really a focal point of a lot of the arguments, a lot of the briefs submitted by the parties in this case, by both the petitioners and the respondents. And as all of labor attorneys are aware, the Encino Motor Cars decision was is certainly a very important decision. There was an anticipation that there would be some discussion of Encino Motor Cars in this decision, and there wasn't. I had actually kind of hypothesized and thrown out a guess that Justice Thomas, who was the author of Encino Motor Cars, may take the opportunity to author this decision as well. These two cases kind of function in, simultaneously function in the same universe. And just briefly to touch on Encino Motor Cars here, this is a decision from, I think, about 7 years ago. It's a 2018 decision holding that exceptions to the FLSA's overtime and minimum wage provisions, again, the exceptions that we're talking about, for example, exemptions for like outside salespeople that we're talking about are to be read in a fair construction rather than a narrow construction. Before Encino Motor Cars, there was a narrow construction, and this was kind of a deference to Department of Labor's interpretation of what these exemptions to the FLSA's mandatory minimum wage and overtime provisions meant. So there was a deference to the agency. They were to be read narrowly within the context of what DOL interpreted it as. Now, instead, after Encino Motor Cars, you have a fair interpretation of the statute. And I think also within the context of this post-Chevron world we're living in this new Loper era, that courts are going to apply their own Article 3 authority to interpret the provisions of the statute rather than necessarily deferring to the DOL's or any administrative agency's interpretation of their statutory authority or their statute. So I think you had Encino Motor Cars, and it was interesting that it wasn't touched on in this case. I think again, just to my kind of fallback answer for why wasn't there at least a mention of Encino Motor Cars? I think that the court didn't feel the need to get into it. I think they wanted to keep it tight, and they didn't want to have to get it. They didn't want to enlarge this any larger than they needed to, and they felt that they could get to the position they wanted to. I think the goal here was for the Supreme Court to kind of say, hey, look, this is the standard now for FLSA exemption cases, FLSA exemption cases. This is how it's going to be applied. It's been applied in 6 circuits. Now it's going to be applied in 7 circuits. So when you're litigating these cases, this is the standard for courts to apply. And I think that's what they wanted to say, that get in, get out, and move on. So that's at least how I read the case, and that's what I make of this omission of Encino Motor Cars. So again, I think that was really an important important kind of something to address here in reading the opinion. Why wasn't Encino Motor Cars discussed in any capacity? I think there might be if you read closely, there might be a little bit of a touch on how to read the statute, that the statute is to be read fairly. So you could kind of possibly read that, but there is no direct citation to Encino Motor Cars in this case. So with that being said, I do think, I think what you're going to see here is the court adopted. There was a little bit of some discrepancy here. Interestingly, at oral arguments, the United States Department of Justice, Department of Labor weighed in on this case, and they had actually weighed in on the side of applying the preponderance of the evidence, applying the preponderance of the evidence as opposed to applying the clear and convincing standard. So they weighed in on the side of the employer in this case. And it was interesting that I think for the first time, Landmark Legal Foundation, my organization, was on the side of the Biden administration's Department of Justice. So they'd actually weighed in on this. I think the goal here was for them, again, seeking a tight decision. They wanted to kind of ensure that the court didn't get into too far afield of a discussion of what necessarily constituted an outside salesperson, whether the factual predicate was met in this particular case. They wanted to keep the decision narrow as well. So I think that's really why the Biden Department of Labor weighed in on this case. At oral arguments, it made it that much more difficult, of course, for the advocate for the employees, where she had a 2-on-1 case. You had not only the attorneys for E.M.D. sales, but you also had the attorneys for the U.S. government, the Solicitor General's office. So whenever you had a 2-on-1 case, I think you're behind the 8 ball in that context. So you had essentially here you had a 2-on-1. The employer's attorneys were kind of dealt a tough hand. I think they were they made the arguments they could as best they could. I think they tried to be as effective as possible. I just think that it was going to be a difficult road to hoe and a difficult case to make, considering the fact that the court had already ruled in the context of, again, litigating Title VII cases, the fact that this doesn't involve constitutional rights, the fact that there's no this statute, the FLSA is silent for it. Incidentally, Justice Kavanaugh did note in his opinion that at the time of the enactment of the FLSA back in the 1930s, that the courts had applied in the default preponderance of evidence standard was applicable in within the civil context. One other thing regarding it too is that we're dealing with the court did look a little bit to remedies here, and what would the remedy here was monetary damages, and that also weighed in on ruling for the applicability of the preponderance of the evidence as opposed to clear and convincing. When you have monetary, I think during an oral arguments, it was difficult I think it was difficult to find any case where when monetary damages were in dispute, whether the higher evidentiary standards would be applicable. And again, we're talking about here constitutional rights, statute says something to that effect, or uncommon cases like termination of parental rights. When you're involving monetary damages, again, the default is going to be your preponderance of the evidence standard here. So that was the takeaway from the court. Interestingly, as I said, the court did not get into an analysis about whether the employer here, E.M.D. Sales, had met that burden. It's only an 11-page opinion, so it reversed and remanded and sent the case back to presumably to the Fourth Circuit. And then I'm going to presume that the district court held a 9-day bench trial here, has a robust factual record, and is going to be able to apply the robust factual record utilizing the new evidentiary standard. Whether the exemption is going to be applicable as to E.M.D. Sales, these individual plaintiffs who initially brought this case, remains to be seen. From what I could discern from reading both the district court's opinion, the circuit court's opinion, the evidence is kind of is contradictory, and so I think it's going to be almost a coin flip. This is the best. Again, I can discern. I haven't read the actual record on the case. I've only read the decisions. So I think the district court and the circuit court had said, look, there was a lot of he said here. There was conflicting testimony. So ultimately, the court, and I think it's going to be incumbent upon the district court to make a decision on whether the actual outside sales representatives, whether the outside sales exemption is going to apply. Just a little bit about what Landmark did and why we felt it was important to file an amicus in this case. Landmark filed, my organization filed a brief on behalf of the National Association of Wholesaler Distributors and the International Food Service Distributors Association. And in our brief, we talk about the importance of outside salespeople and the need for this exemption to apply. We delve a little bit into the history of why the outside sales exemption is applicable, the role that outside salespeople play, the unique and special role that outside salespeople play, and what would have been kind of the larger effect if the Fourth Circuit's decision was to be affirmed, and God forbid there was suddenly going to be either a higher application throughout the country. In other words, taking the 6 circuits that were that were differing from the Fourth Circuit and bringing them all into line with the Fourth Circuit. Imagine that, and the deleterious effect it was going to have on companies throughout the country that utilize these outside salespeople. We were talking about that outside salespeople have to have a lot of independence. They have to have flexibility. Oftentimes they don't necessarily will keep track of their hours to the minute. They have to develop relationships with the clients. Sometimes their days can start as early as 6 a.m. and they can put in 80 hours in a given week, trying to develop new sales leads and maintain necessary flexibility. Whereas in other instances that they could be working 20 hours a week. So each day was kind of unique, and the need for this flexibility was important. And that was essentially the need for the exemption in the first place. Also, I think the need for applying this evidentiary standard for all of these exemptions is important, because the FLSA, when you really get into the purpose and point of the FLSA here, is to promote employment, and is to ensure that where corporations could utilize multiple, could split the differences. There should be some certainty. And I think the application, again, of this preponderance of the evidence standard is going to give certainty for employers throughout the country, and is going to really ensure that people keep their jobs. I think probably part of we surmise that some of the effects, should the court have adopted the higher clear and convincing standard, would be that a lot of corporations would simply eliminate their outside sales positions because they just couldn't deal with the possible exposure that they would have faced had they had to survive, had they had to overcome a clear and convincing burden with regards to some of their outside salespeople. They would have simply made these individuals independent contractors, and so employment as a whole would have suffered. So that was essentially what we were really arguing in front of the court. Again, we were pleased with the decision. How it shakes out as it pertains specifically to E.M.D. sales and to the parties here remains to be seen. Again, as I said, the court reversed and remanded the decision. Real quickly here, I do want to talk about the concurrence by Justice Gorsuch and joined by Justice Thomas. Again, I encourage anybody with easily just 5 minutes to just take a quick look at it. And when we first read the opinion here, it is essentially just one paragraph long. And in those cases, and what essentially Justice Gorsuch says, I'm just going to quote from his concurrence, what we felt was the operative paragraph here. Occasionally, and again, quoting from the concurrence, occasionally, though, the default common law rule provides instead for a heightened standard of proof, which must be applied unless Congress changes it or the Constitution forbids it. So they are touching on common law provides for a heightened standard of proof. And also Justice Gorsuch notes where constitutional rights are at issue. So he's talking about constitutional rights at issue, and common law rule provides for a heightened burden of proof. So he concurs in the opinion. He says the court gets it right. In this context, we're going to apply preponderance of the evidence. However, occasionally, there's going to be instances where a higher standard of proof is applicable. And, here at Landmark, I read this and I said, what does that mean? Well, my good friend, Professor Josh Blackman, posited a hypothetical that he posted on a blog, and he kind of made a guess as to what's behind the meanings of this term. What was he thinking? And Professor Blackman makes the guess that Justice Gorsuch and Justice Thomas are telegraphing a position that they might hold in Title IX cases. Again, so these are cases regarding sexual harassment, or in the context of the university in university context. So he kind of expands on this a little bit. With the incoming administration, there might be some new rules that are going to go into effect that are going to raise the standard of proof that universities must meet within the context of Title IX cases. And again, here we're talking about that there might be a constitutional issue at play here, and that is due process rights. In other words, are some of these individuals who are being disciplined under Title IX, what is the proper evidentiary standard here? And the Trump administration might be poised to raise that in via regulatory rule and say, look, the standard here in litigating these Title IX cases is going to be a higher, clear and convincing, because it either involves a constitutional due process right, or maybe involves a common law rule that provides for a higher standard. So he kind of is guessing. Is hypothesizing that this, in the context of Title IX, Trump and then later on might be poised to put a new rule into effect that demands a higher evidentiary standard here. Because a lot of those cases are he said, again, you're talking he said, she said, and it's oftentimes difficult to get to it. And so raising possibility that the higher evidentiary standard might be raised in the context of Title IX. So thanks to Professor Blackman for that, because I read the paragraph and I simply said, what are they trying to say? I don't understand. Obviously, this means something, but what does it mean? It's a short concurrence. Again, I encourage anybody out there to take a look at it. Furthermore, I encourage everybody to take a look at the opinion as a whole. Again, it's a tight opinion. I was talking earlier before I came on that this is with some of my colleagues, some of our research fellows here at Landmark, that this is a good opinion if you want to get a quick synopsis of evidentiary standards. And if you're a law student or if you're somebody approaching this with fresh eyes, you might want to say, well, how do I apply these evidentiary standards? These are confusing. You're throwing out terms of reasonable doubt, clear and convincing, preponderance of evidence. What do they mean? Why do they mean what they mean? And I think if you want to get kind of a crib notes version of this and if you have your time is limited and your time is short and you want to understand at least on this, initially and get an introduction to how courts are going to apply these evidentiary standards and when they're going to apply these evidentiary standards, I think you can really look to this E.M.D. Sales versus Carrera for some guidance on that and see how courts wrestle with these in the civil context. Of course, we're talking the criminal context, we have the burden of proof, but within the civil context, being very frank, oftentimes, I'll throw out preponderance of evidence and clear and convincing, and it's very easy to mix these sorts of terminology up. But I think if you want to look at this opinion for a concise description of why certain evidentiary standards are necessary in certain contexts, I think you can look to this for guidance in that. Again, this is the good takeaway here is there's now uniformity amongst the circuits. Now, instead of having a 6-to-1 circuit split where you have the Fourth Circuit functioning as an outlier, applying this heightened evidentiary standards in FLSA exemption cases, now you have the Fourth Circuit that's been brought back in line with the other circuits. So you have a uniform application of evidentiary standards. I think that's a good thing going forward. I think it brings certainty to the law. I think, of course, it's going to discourage any kind of venue or forum shopping. I think it's going to be consistency for practitioners going forward, too. And again, the takeaway as pertaining to the specific litigants in this case, I think that remains to be seen. You had a 9-day bench trial. You had a robust factual record that I think it's going to be incumbent upon the district court judge to utilize the new paradigm that's been established here in the Fourth Circuit by the Supreme Court, and utilize that paradigm to take fresh eyes and look at the evidentiary record and make a conclusion, make a judgment call. With that being said, I don't know whether there's any questions or anything. Marco, is there anything on your end, any takeaways or any questions or anything you feel like I might have missed over, or that I was a little bit not as clear as necessary or as concise as necessary?
Well, I don't see any questions from the Zoom chat,
Okay.
And I'll take that to mean that you answered any potential questions already. So I'll let you give any final thoughts you might have. And if there's still no questions by the end of that, we can wrap it up.
Yeah, I'm just looking through my notes here. I want to just see whether there's anything that I possibly missed. I think, it was interesting, again, just to touch on the 9-0 decision. I think it's always good to see. It's funny because a lot of the public likes to make, you'll get the common narrative that the court is hopelessly divided, that there's all this, there's dissent in the court. I generally like to see, from an institutional perspective, I like to see 9-0 decisions. Again, Chief Justice Roberts, focuses on, he's always said, from the day he was nominated, balls and strikes, is going to keep his decisions there. And I think you can look at that. This is just a continuation of a typical Roberts court's decision. You have a uniform 9-0 decision, tight, doesn't get into a lot of extraneous analysis of factual situations or any kind of social policy, sticks really with the question at hand, and you have a tight takeaway and a tight holding. And I think in cases like that, I appreciate that. I don't think there's anything else I really wanted to hit on. I think it was interesting that there was. I do think one interesting point, another takeaway, is to touch on the Fourth Circuit's reliance on this. And if you want to delve into this, you can kind of see how, a one misstep decades ago can reverberate decades later. You have a misinterpretation of a case. Incidentally, it was funny that the case, the Fourth Circuit utilizes, this higher evidentiary standard. You say, well, where did that come from? Well, originally it came from the Fourth Circuit relying on a 10th Circuit's decision. And the 10th Circuit reversed its decision. And then so you had the 10th Circuit saying, wait a minute, we made a mistake here in the 1980s by applying the improper standard of proof here in these cases, evidentiary standard. We're gonna reverse our decision on an en banc decision. This is the 10th Circuit doing it. Well, that wasn't enough for the Fourth Circuit. The Fourth Circuit said, well, even though the 10th Circuit, where we had originally gotten where we originally relied on, even though they reversed their en banc decision, we're still going to hold fast to our rule here. So I think you can see the issues that kind of arise, and when you have the benefit of hindsight, you can look back all the way to the 1980s and a misinterpretation of one case, and then it's subsequently building on itself. Again, can come back and haunt you even 30, 40 years later. I am appreciative of the fact that the court did take this case and was able to remedy that, and again bring some certainty to the issue here. And again, I think it's interesting that Justices Gorsuch and Thomas took the opportunity here to possibly, as Professor Blackman hypothesizes, to possibly give a little bit of show a little leg on where they might be standing in Title IX cases here, and that the applicability of a higher evidentiary standard in those cases, because it involves, of course, a constitutional issue, or an the common law rule provides for a heightened standard of proof. So we'll see. That is to be continued, and we'll see whether in the next couple of terms whether those cases are litigated and brought before the court. With that, I think I've spoken enough. If there's no questions, or if there's any thoughts or anything, Marco, you might have, I'll turn it over to you. I appreciate the Federalist Society's opportunity provided to me to be able to give this. As you can tell, I was in the weeds for a while in this case, and I'm happy to talk about it. If anybody ever has any questions or anything about this, or how it's going to be applicable going forward, don't hesitate to reach out to me. My email is mike@landmarklegal.org. Again, this was a fantastic opportunity. I really thank our clients, the National Association of Wholesale Distributors and the International Food Service Distributors, for the opportunity to file a brief on their behalf. And I appreciate the opportunity to talk with you, Marco, and all of the FedSoc members about this case.
Well, absolutely. And we're so grateful that you have been able to participate and lend us both your time and your considerable expertise. On behalf of the Federalist Society, I would also like to thank you, our audience, for joining us. We greatly appreciate your participation. And on that note, we are adjourned. Thank you.
Thank you for listening to this episode of FedSoc Forums, a podcast of the Federalist Society's practice groups. For more information about the Federalist Society, the practice groups, and to become a Federalist Society member, please visit our website at fedsoc.org.